Good afternoon. For those of you who don't know me, my name is Christopher Diorio. For those of you who do know me, my name is still Chris Diorio. Welcome again to ChrisChat. This is ChrisChat number 4. We'll wait for things to populate a little bit here. We will be discussing today the First Amendment again. But a different portion of the First Amendment today, and this I took from a few suggestions. We'll be talking about the First Amendment's free speech protection relating to symbolic expression, regarding what speech actually is. We'll deal with all of that. We'll also talk about hate speech, and I think that that's one of the topics, both symbolic expression and hate speech, being something that's coming up a lot recently in the political discussion. So I want to get into that as well and give you an idea as to what we're talking about in terms of what is protected, what isn't protected, just to give you a better sense as to what your rights are and what the rights of the government are. And that's always the interplay that's going on here whenever you're discussing the First Amendment or any of the individual rights that are granted to us constitutionally in the Bill of Rights and beyond. You're always looking at discussing what is the balance between the right of the individual to exercise their individual rights, as well as the right of the government to espouse a particular belief or to, in some cases, suppress a certain amount of speech, or to engage in law enforcement activities regarding that speech. So before you get a sense of what we're looking at and what we're going to discuss, you first have to understand what speech is, what is protected and what isn't. James Madison was the author of the First Amendment, and he was very emphatic about saying that there should be no state involvement with speech. He referred to the First Amendment and the prohibitions against the government interfering with speech as being the most valuable amendment on the whole list. I've said it to friends before, and I'll say it again. The reason why the First Amendment is first is because it's that important. To a general understanding, speech is the spoken word at its base level. But what else is speech? Speech is also expressive conduct. And that's something that we'll talk about in a little bit when we deal with individual rights and what counts. Expressive conduct can be such a thing as, in certain circumstances, dancing. Expressive conduct can be any variety of different things. But what you also have to understand is that you may believe that something is expressive when it's not. There are certain restrictions. There are some people who believe that, if you look at speech, expressive conduct can be something like burning a draft card. Expressive conduct has been deemed to be burning a flag in certain circumstances. But there are tests that determine what counts as speech. And there are 3 different ways to look at what gets protected. There's an absolutist view that says that, all speech, that the prohibition in the Constitution says, or in the Bill of Rights, in the First Amendment says, no law, Congress shall make no law inhibiting the right to free speech. No law means no law. That's what the absolutist position is. There's a second category called the categorical approach, which basically whatever label gets put on that speech, that determines whether it counts as speech or not. So if I were to label a particular type of speech as obscenity, then obscenity is not protected. But if it's labeled in a different fashion, then yes, it is. The third approach that you look at in the First Amendment is a balancing approach, which really, as I just discussed earlier, says we have to look at both the individual right that's being engaged in, and then you have to look at what the government's interest is in addressing that particular right. By and large, what happens in these situations is the individual wins out. There's a test that was created years ago, right in a case involving a person by the name of David O'Brien, right here in Boston. During the Vietnam War, he stood on the steps of the courthouse and burned his draft card. He was prosecuted for that, and actually had a suspended sentence attached to it, but the Supreme Court created a test as a result of this that said that the government regulation regarding this type of expressive conduct has to be within the government's power. It has to further a substantial government interest. It's starting to sound familiar, like that compelling state interest test we talked about last week. It has to address a compelling state interest. That interest cannot be related to the suppression of free expression. And whatever restriction is placed on that conduct, that expressive conduct, can't be any greater than is essential for the furtherance of that interest. So that's the test that gets applied whenever you're talking about free speech or free conduct, or expressive conduct in this particular circumstance. What we're looking at is what counts, what gets dealt with in terms of free expression, what counts as expressive conduct and what doesn't. Because there are certain types of speech that are not protected, regardless of whether you're an absolutist or not. The Supreme Court does not recognize protection for certain types of speech. Obscenity is one. But what you're dealing with in obscenity is defining it. United States Supreme Court in 1973 in Miller versus California attempted to define obscenity, dealing with contemporary community standards and whether the work as a whole addresses the prurient interest in sexual conduct or whether it turns sexual conduct into an obscene gesture, things of that nature. Nobody has really been able to properly define obscenity because, and the problem here is, they talked about contemporary community standards. The standards here in Boston are different than the standards in Utah and different than the standards in Texas. So when you talk about contemporary community standards, you never really know what the definition is. So that's one of those things that's not protected. Yelling fire in a crowded theater, that's one of those types of speech that, along with the fighting words doctrine that came out in 1942 in Chaplinsky versus New Hampshire, where you're doing something or saying something that would incite imminent lawless action or incite riot. And in a case of yelling fire in a crowded theater, that is one of those things where you're going to then cause, as a result of that statement, people to react in a certain riotous fashion, heading for the exits and causing damage. Chaplinsky was interesting. In 1942, a gentleman, he was a Jehovah's Witness, who walked up to a police officer and referred to him as a goddamn racketeer and a fascist. That was enough. That was considered fighting words at that point in 1942. And therefore, he was prosecuted and his speech was sanctioned. The test that the court created as far as fighting words is those types of words that are wholly outside of the First Amendment because by their very utterance, they inflict injury. And these types of speech have no essential part of the exposition of ideas. That's what's not protected with fighting words. And that's 1942. Honestly, after that case there haven't been a whole lot of cases that talked about fighting words at all that have reached the Supreme Court. But we have a definition. Things that are likely to incite violence or likely to incite a fighting reaction. What about cross burning? There are Supreme Court cases that have addressed this very specifically. And given the current political climate, I think it's only fair that we discuss these types of circumstances. There was a case in Minnesota in 1992 dealing with a gentleman who burned a cross on the lawn of an African-American family. There was an ordinance in St. Paul, Minnesota that said that if you if you place a symbol that is likely to arouse anger, alarm, or resentment on the basis of race, religion, or gender. And cross burning fit into this particular statute. And Robert Victoria, the young teenager who burned the cross, was prosecuted as a result. Justice Scalia, in the case of R.A.V., Robert A. Victoria, he was a minor at the time, so they had to use his initials, versus St. Paul, struck down this particular statute as being unconstitutional, and in essence said that you cannot punish this type of expressive conduct because it has a particular meaning to a particular person. Using his language, he reversed the conviction of Robert Victoria and said that the ordinance itself was unconstitutionally criminalizing certain hurtful expressions while not addressing others. That basically the legislators, by saying race, gender, or religion, picked and chose what was allowable in terms of sanction and didn't address others. In essence, they protected what individuals wanted to protect. Those individual legislators sought to be protected. So is cross-burning legal? The answer right now is it depends, and that's addressing the statutes and really abides by the statute that we deal with. There was a case that came very soon after that, Virginia versus Black, and another one in Wisconsin, Wisconsin versus Mitchell. Both of their statutes were very specifically upheld as being constitutional. In Virginia versus Black, the majority said that the cross-burning statute that they had fell within one of the RAV exceptions that said that because their statute read differently. I can read you their statute specifically, and you can compare the difference. The statute in Virginia said that it's unlawful for a person with the intent of intimidating any person or group of persons. So it doesn't say race, gender, or anything as the Minnesota statute did. Causes to be burned a cross on the property of another, a highway, or other public place. That was their statute. It didn't say anything specifically about race, gender, or religion. It is content neutral. All it says is that if you burn a cross, and it is with the intent to intimidate, then under those particular versions of the law, you cannot burn the cross. So, is cross burning legal? Not particularly. Most cases and most statutes after the RAV decision that Scalia decided in 1992 changed their wording if they do in fact have cross-burning statutes that says that if the act is done with the intent to intimidate groups or particular groups of people or an individual, then it's then that particular conduct is not protected. Cross-burning itself is considered expressive conduct. It does trigger a First Amendment. Examination, but under the current circumstances, it's not considered unconstitutional to ban cross-burning. Excuse me. One of the other questions that I get asked about a lot, and it is something that comes up fairly often now, and has come up more often, in terms of hate speech and bullying and things of that nature. Many college campuses are creating hate speech codes, and these codes, frankly, they serve very little purpose. In fact, they do more harm than good. In terms of what you're talking about with the First Amendment. Many universities, under the pressure to respond to concerns of people who are objects of hatred or some otherwise being picked on or something of that nature, have passed these have passed these particular hate speech codes. I try to educate with these things, but right now what I'm going to say is that these types of codes, these types of hate speech protections, they're well-meaning in a sense, but they counter very specifically what the First Amendment allows. The Constitution protects speech no matter how offensive it is. In fact, why have First Amendment protection if you're not going to address these people? I mean, our First Amendment is tested the most when we're facing off against people who are saying hideous, horrible things. Those are the people that get protected. It's people like Larry Flint who published a parody ad about Jerry Falwell and said that the first time he ever had sex was with his mother in an outhouse. And Falwell sued Larry Flynt, the publisher of Hustler, for publishing this. And the United States Supreme Court, in a unanimous decision, by the way, said that this type of restriction of conduct is not permitted, that this is classically what should be protected. How much we value what the right of free speech is put to its greatest test when the speaker is someone with whom we disagree the most. So you've got people like Donald Trump out there saying hideous things, and if he's inciting people to violence, that's one thing. But if he's just simply saying horrible things, he may in fact be a reprehensible person, but he's allowed to say these things. When one of us is denied a right to speak, we're all denied the right to speak. Wherever racist, sexist, homophobic speech is present, suppressing the speech doesn't necessarily cure the problem. It's addressing the symptom. More speech is better. It's, quite frankly, the better path instead of speech codes. These codes are, constitutionally, they're not the way to go. They may make people feel better about themselves and create a secure bubble, but they're not really the way to go. You have to address these things in a certain fashion, and this is not it. It's not the way to go with this. I'm looking for something here and I missed it. There it is. You have certain viewpoints that have to be allowed to express themselves, put them in the light of day. That's the better way to go. I mean, colleges who look at these hate speech codes, and schools and universities and even high schools now who have these hate speech codes, they're very attractive. They're a quick fix. They really make people feel good. But constitutionally, creating a zone of verbal purity does not enact social change. It just doesn't. All you're doing with speech codes is addressing the symptom. The root cause is bigotry. And if you don't address that, why have this protection at all? You're cutting directly at the heart of free speech. Free speech rights are indivisible. They are the same laws that will be used to inhibit this speech could potentially come right back and harm you. So when you start going down that road, it's only a matter of time before these things get turned back around on you. You have to defend First Amendment rights for everybody. Everybody. Even people who you may deem to be the enemies of civil liberties and civil rights entirely. Defending them means defending you and me. That's simply the way it goes. When it's different, however, when you are looking at hateful speech that is directed at an individual or a particular group of individuals directly. That's where you're talking about inciting violence. That's where you trigger Chaplinsky and fighting words and things of that nature. If you're addressing it to an individual, by all means, address that. But when you are simply doing something in general and affecting groups, etc., that's different. We have this fighting words protection, but it hasn't really been applicable to anything. There's nothing that's come up that's been addressed. These swastikas and things that we're seeing now, and burning crosses and the nonverbal symbols that we're addressing with free speech and hate speech, they're constitutionally protected. If they're worn, if they're displayed in front of a general audience in a public place, at a march, at a rally, what have you, those types of conduct, they're protected as expressive conduct. It doesn't, however, protect when you go directly to a person and get in their face or on their private property and you burn a cross on their property. That's something different. That's something entirely different. You have to have this type of freedom, because when you start going down this road of when, what speech we want to have and what speech we don't want to have. This actually works against the interests of people that, in some respects, these types of codes are designed to protect. The ultimate power here to decide what speech is deemed offensive and to whom it's offensive ultimately rests with the government and rests with authority figures, and rests with those people who pass laws. And if we're going to have that, the power doesn't rest with the victims. So these victims are not being benefited by this. It's creating a bubble that ultimately doesn't address the problem. It doesn't address the underlying bigotry that's there that results in this type of speech. If you ban bigoted speech, if you ban offensive speech, it doesn't end the bigotry. Even if it chills some of the really crude types of expressions of these things, but the codes themselves deter students from saying out loud what they would only think in a private room. I've written it before on Facebook, and I'll repeat it again. My father had a saying that, I'd rather the burglar break the window and make noise when he comes in than tiptoe up the stairs. You want to know where these people are. You want to know who these people are, and you want to know what they're thinking. You don't want this stuff to germinate in dark rooms, underground, deep in the muck where you can't see where they are, because you can't then address it. It's termites in the wall. You can't really address the problem if you can't see it. So burying it and pushing them back into dark rooms doesn't help solve the underlying problem. More speech does, not less. Activists getting out there and speaking at the top of their lungs against what these people are speaking about at the top of theirs, to paraphrase the American president from years ago. More speech is better. It always is. Put these things in the open marketplace and let truth will. That's what's going to happen. But if you continue to suppress it and stamp it down, sooner or later, it's going to come back. Speak loudly, speak clearly, address these things, because these types of speech address hateful, horrible conduct. It's this type of speech that provokes. It's this type of speech that ultimately has to be allowed out in the open. Because if we don't protect something that offensive, then why have the First Amendment at all? It's very similar to flag burning. Why have a protection against offensive speech if it can't address the most virulent of things that we hold dear? Like this. This flag flies over our Capitol. This flag flies over military bases and schools. This is a flag that flew at Iwo Jima, that represented our power in the world. This flag triggers hatred around the world. This flag is worn as a symbol of honor, as many, many people do, serving the military, serving our interests. This flag drapes the coffins of those who come back from serving and give the ultimate sacrifice. This flag and flags just like it stand at the graves and mark the graves of those who served and gave the ultimate sacrifice, or any sacrifice at all, those who served. And this flag burns. How did that feel? What type of message comes from that? How does that get to you? Seeing that is the ultimate form of expression, and it is the very thing that needs to be protected. It's that type of conduct that needs to be protected, that expressive act. It cuts to the very heart of who we are as Americans. And if we cannot protect that act, then the First Amendment is meaningless. So says our United States Supreme Court. In 1984, a gentleman by the name of Johnson was protesting at the 1984 Republican National Convention. Ronald Reagan was running for re-election at that point. And he followed a group of protesters, and at one point, the protesters gave him a flag. And he set it on fire in front of the Dallas City Hall. He was prosecuted for violating their statutes regarding flag desecration. Very similar to the flag code that I see posted all the time around here. But he was prosecuted for burning a flag. The United States Supreme Court in Texas versus Johnson said that this type of symbolic expression, and it is in fact symbolic expression, is worthy of protection by the United States Constitution. Very similar to, it took that test from O'Brien and made it into their own standard as far as what is protected. Greg Johnson was convicted for burning that flag, and the United States Supreme Court said that that flag burning was in fact speech. And again, determined that flag desecration statutes and any attempt to do so was directly aimed at the communicative message of that burning flag. When you pass laws that are very specifically directed at that act, you are violating the First Amendment. And anyone who talks about flag burning amendments and anyone who talks about punishing people for burning the flag is directly in opposition to the First Amendment of the United States. I quote directly from Justice Brennan in the Texas versus Johnson decision. There is a bedrock principle underlying the First Amendment, and it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. We have not recognized any exception to this principle, even where the flag is involved. It is permissible, expressive conduct. The government cannot prohibit expression simply because it disagrees with the message. That's not allowed, and that's what flag burning is. It sends a message, the message that was sent here 5 minutes ago, that this is an allowable means of expression. It is not dependent on the mode that you exercise that expression. It is not dependent on anything. If we were to hold that any state or the federal government can forbid flag burning wherever it is likely to endanger the flag's role, but allow it to be burned for any other purpose, including disposing of it lawfully, then what's the sense of having it? If we're permitting the state to prescribe what they want to be orthodox behavior, then what's the sense? It endangers what the flag represents entirely. The United States Supreme Court in Texas versus Johnson, and every time that a flag burning amendment has come before them, has rejected the notion that the flag deserves special protection. The Supreme Court declines to protect the flags specifically or make it an exception to those principles that are addressed every day when we're talking about the First Amendment. The way to, and the decision in Johnson discusses how important the flag is and how cherished an emblem it is. And I love this country, and I love what this country allows me to do, including what I just did. If I did that anywhere else, there'd be people banging my door down right now. The flag has a cherished place in our daily life and in our community. But being allowed to burn the flag doesn't weaken who we are. Frankly, it strengthens who we are. It reaffirms the very principles of freedom and inclusiveness that the flag best represents. Toleration of criticism, toleration of things like burning a flag is a sign and source of our very strength to be able to do this. One of the proudest images of our flag is it being bombarded. The shredded version of the flag that appeared at Iwo Jima. The shredded and burned version of the flag that flew over the rubble at 9/11. It's this type of stuff that directly looks at our nation's resilience. And no burning flag can tear away at that. It's that resilience that permits that type of conduct to even exist. It's precisely because when the flag is involved in protest, one's response to a flag burner may be, to exploit the unique persuasive power of the flag itself. There's no more appropriate response, in my estimation, than waving your own flag. There's no better way to counteract a flag burner's message than to salute the burning flag. There's no surer means of preserving the dignity even of the flag that burned than by according the flag the respect that it deserves. You do not consecrate the flag by punishing its desecration. When you do that, all you're doing is diluting the very freedom that the flag represents. Burning a flag is an exercise, but it is no less a message. It is no less speech. It is expressive conduct protected, and it has to be. What I hear, though, a lot is people who talk about the flag code, the U.S. flag code, regarding respect for the flag. Well, I've read the flag code, and it's been rendered unconstitutional in most respects regarding flag burning specifically. But the folks that talk about flag burning as being anti-American are also very similarly the same folks that violate the flag code on their own. I'll read directly from it. The flag should never be used as wearing apparel. That means all of those bikini bathing suits out there with the flag on them, get rid of them. If you attach a flag to the back of a leather jacket when you're riding on a motorcycle, or you're doing the flag disservice. You yourself are violating the flag code. It should never be fastened to something in a way that it would allow it to be torn, soiled, or damaged. Well, all of these folks who ride down the highway with their pickup trucks and their great big American flags whipping in the breeze, tattered, mind you, are in fact violating the flag code. And yet, if I did what I did here and burned the flag, they would be all over me. Drawing a line is interesting. The flag should never be used as a receptacle or a receiving item for holding, carrying, or delivering anything. So, get rid of your American flag plates for the 4th of July. Let's just have regular plates. No part of the flag should ever be used as a costume. People have done that in the past. It is not a fitting emblem for display. And further, they refer to the flag, if you want to talk about, well, it's just a plate or something of that nature, a napkin. The term flag of the United States as used in this section includes any flag, ensign, or any picture or representation of either, or of any part or parts of either, made of any substance or represented on any substance of any size, the color, standard, flag, or ensign of the United States of America. or a picture or representation of either. You can't use the flag to wipe your mouth and then go after someone as un-American when they do something expressively against the flag. It is against the First Amendment directly. That's what I have today. If you have any questions, I'll be happy to answer them. I'll sit tight for a couple of seconds. But ultimately, what you have to understand is this. Free speech means free speech for everybody. No law, in a sense, means no law. A person has to be allowed to express themselves, to put ideas out there in the open marketplace, to have some degree of freedom in their ability to speak. And only in those certain limited circumstances where speech is necessarily restricted, should we inhibit it. Obscenity, child pornography, inciting violence, imminent lawless action, reporting troop movements overseas, libel, slander, things of that nature are unprotected because they don't add to the political discussion. They don't add to the social ideal. They have less value and don't promote. They inhibit or destroy. But even then, having these ideas out there in the open marketplace only benefits us. Even the most hateful of speech, even the most derogatory of speech, and I get it, I understand about how, how can we talk about this and allow this type of speech to take place regarding races, regarding ethnicities, regarding the LGBTQ community. I understand all of that. I get it. I would rather that speech be out there than have it buried and only be surprised by it later on when you see how virulent it has become growing in the dark. If there's nothing else, if there are no other questions, thank you very much for tuning in to ChrisChat. I will likely be discussing, as we are in the Christmas season, my plan, or the holiday season, for those of you who don't celebrate Christmas or celebrate other holidays during the winter. What I want to discuss next week right now is the Establishment Clause and the holidays, how we are allowed to have the First Amendment say that government shall not establish a religion and yet have a manger on the steps of the courthouse or in front of City Hall. And then the week following that, what I would like to discuss is the Muslim registry. So that's my plan for the next 2 weeks. If people have suggestions, send me messages, send me emails, message me here on Facebook. Again, thank you very much for stopping by for ChrisChat. This will be posted as a video and made public if you wish to share it. But otherwise, thank you very much for stopping in and have a good day.